Can you win your asylum case in court? The answer is yes, you can. And in this video, I am going to show you how. My name is Bijoux Ngwanda. I'm an immigration lawyer based here in DC. I do work with individuals across the country and around the world because we're dealing with complex U.S. immigration law cases. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing, and please do not forget to hit the notification bell so you don't miss any of my videos. If you enjoy the content, you go ahead and share, like, and don't forget to comment below. Also follow me on Instagram because we're talking about employment-based immigration, the business side of immigration, investment, entrepreneur parole, self-petitions, and more. Let's get right into the subject. Most of the time, right, cases get referred to immigration courts because of two things: failure to establish past persecution and inconsistencies in the testimony. Two things. Most of the time, that's why the case gets referred to immigration court when it comes to asylum. Okay, so let's start with inconsistencies in the testimony of the applicant. Now the applicant becomes the respondent before the immigration judge. Well, why they failed to establish past persecution? Because the testimonies were inconsistent. Remember, the basis for asylum is that you have to establish a well-founded fear of persecution in the past you were persecuted, or a well-founded fear of persecution in the future, that you're going to be persecuted in the future. When the testimony lack credibility or they're talking about inconsistencies, well, that's when you are now before the immigration judge. Remember this. When you want to establish past persecution now in front of the immigration judge, you do not have to have a lot of evidence, right? If you don't have the evidence, don't make up evidence, because otherwise now your claim will be frivolous because you are making up stuff. If you do not have evidence to support your testimony, just go with your testimony alone and make sure you add some credibility to your testimony. Remember that the judge, the immigration judge, is not required to question every inconsistencies in your testimony. However, the immigration judge has to look at the totality of circumstances, right? So if you don't have a lot of evidence to support your testimony, you can bring another witness to support your testimony. Basically, the witness is going to be testifying for your credibility, for your story to be believable. It can be an expert witness or a lay witness, somebody who's not an expert, but they have personal knowledge of you or your story, or just you, your character and moral, because you want to boost your credibility so that the immigration judge can believe your story. Because remember, the person is referred because of inconsistencies, right, in the testimony. That's why they failed to establish past persecution, right? So that's how you get to the past persecution test. Really, your testimony alone is sufficient. You can boost your credibility by adding another witness who will testify as to personal knowledge of you and your story, or an expert witness who's going to testify about the conditions of the country. And remember that the conditions of the country report, you can get it from state government, Department of State.gov. It has all the conditions of the country to support your testimony. That's how you meet the eligibility requirement for past persecution. However, let's just establish that for the purpose of this video, you fail again in court to establish past persecution. You still have a chance to make your case in court when it comes to asylum, because you can now establish the well-founded fear of future persecution. And this test really only, the way it works, it's so simple, right? The test for future persecution, fear of future persecution, it's basically that the applicant needs only showing that such fear is grounded in reality and it meets the objective and subjective tests. So in other words, the applicant must establish both that he has subjective fear of persecution and the fear is objectively reasonable. Subjective is basically just applies to you, that fear is subjective to you, and it's reasonable that you were afraid, that it's so reasonable that under those circumstances, a reasonable person would be afraid to go back. So, and that's really a low standard, right? And then what are you going to present? So you must present reliable, specific, and objective evidence, right? But remember that the applicant fear may be well-founded even there is only slight chance of persecution. Even if the chance for future persecution is slim, you can still meet the test for fear of future persecution. So now the question becomes, why a lot of people get denied their the asylum even though they meet? Because remember, I'm talking about the standards so low, and why a lot of people get denied their cases for asylum. If they fail to establish past persecution, however, they can still establish the fear of future persecution. So, but why they get denied? Because of the third point, the discretionary factors. Negative factors can lead a judge to deny the case. And how negative factors come into play? Well, if you have criminal background, for example, if you lack good moral and character, if you can't even hold a job, like they gave you work permit and you can't work, you're just relying on a lot of things, it's pretty much negative factors, right? And some people, they actually are here and they leave the country, they ask for advance parole, they go back home and come back, and then the judge looks at all that and say, well, if this person really fears persecution, how come they're able to go and come back on advance parole? Remember, when somebody's asylum is first pending with USCIS, they have the right for advance parole, right? And that's why we strongly discourage people to ask for advance parole, because if they end up in court, all that is going to be factor into the decision of the judge. So negative factors are the things that lead an immigration judge to deny an asylum case, even though the person has met all the eligibility requirement and able to credibly testify, credibility of the testimony, fix the inconsistencies in the testimony, basically past persecution, and be able to establish a well-founded fear of future persecution, and the person still gets denied because of the negative factors. Okay, remember, asylum is a discretionary measure, and sometimes the judge has to wait. Okay, negative factors and your testimony, what can be done about it? So, but remember that in order for the judge to exercise their discretion, in absence of those negative factors, the judge has no choice but to grant you asylum. So that's why you need somebody who can actually look at your case in details, pinpoint all the details of the case in order for you to have a better chance at winning. Okay, to have the better chance of weighting those negative factors when it comes to determining whether or not you will be eligible for asylum in court, because remember, if you get asylum in court, the game is over. You get your work permit, you get your travel document, and you wait for 1 year before applying for the green card, and you can reunite with your family, especially even the children that has passed 21, provided that at the time you apply for the asylum application, they were under 21. So this is really something that you have to really consider when you're trying to go to court. Check out, have a qualifying attorney to help you out so that you can win in court. And again, can you win in court? Yes, you can win in court. We have won in court. As a matter of fact, we even won without any other testimonies except for the actual applicant testimony. You know what I mean? We did not have evidence, a lot of evidence to support the testimony, but we went with the testimony of the applicant themselves. And the judge found that the person had credibility to testify, and that the inconsistency, that the reason why it was referred, because of the inconsistency. Remember, the inconsistency can be weighted as negative factors, but the fact that he overcome it by responding, the judge weighted that and said that inconsistency factor in that particular case did not outweigh the possibility of the judge to grant asylum. And the asylum was granted, and no appeal from the DHS. That's how you want the thing to be done. That's how you get your case done in court, and that's how you win in court. Representation matter. If you need a consultation with me, 202-751-2180. Email Bijoux.Ngwanda@esq.com. Consultation fees apply as usual. My lightning is just like flashing, so I had to cut this thing off. But until next time, bye-bye.